Afternoon, Judge.
Good afternoon, Mr. Wilder.
Good afternoon,
Yeah.
Judge.
Good afternoon. Mr. Hughey, can you hear or see us?
Hold on for a second, Your Honor.
We see your name.
I'm here. I'm trying to get the camera on. I guess it doesn't want to cooperate with me. Can you hear me, Your Honor?
Yes, we can hear you.
Okay, I'm trying to.
Now we
Okay.
see you.
There
Okay.
you are, man.
All right.
All right. All right, this is cause number 2022-298, Michael Flowers et al. Versus Willie T. Freeney et al. This is Mr. Hughey's motions for clarification on orders. And I'll note that this is being broadcast over YouTube in order to comply with open court doctrine. All parties and counsel are present via Zoom. And is everybody ready to proceed?
The Freeneys are, Your Honor.
Mr. Robertson, you're muted.
Okay, how's that?
Yes.
Okay, yeah. I'm here and ready to go.
Mr. Wilder, you ready to proceed?
Yeah, I'm the ad litem and we're ready to proceed.
All right. You may proceed, Mr. Hughey.
Yeah. Your Honor, we got to stop meeting this way, but in this matter, my motion centers around actually an order. We got conflicting orders. Back on October the 21st, the court signed an order basically denying our motion for reconsideration to basically to have my clients to get a small portion of the land in kind as versus being sold. In that particular order was language that said that the order was appealable. On the 31st of October, I filed a notice for appeal in the Sixth Court of Appeals in association with the October 21st order signed by the court. On November, I guess, the 7th, the court signed an order submitted by Mr. Robertson that denied the Freeney's original motion for reconsideration, but it did not contain appealability language, but it also did not state that it either was an amended order or it superseded the court's October the 21st order. So that's the first issue, because my appeal was filed in the Court of Appeals on October the 31st, predicated on the October 21st order. And then Mr. Roberts filed and the court signed an order on November the 7th. And well, it was after I filed a notice of appeal, but there was no language in that particular order that either stated that it superseded or it was amending the order that the court had previously signed on October the 21st. So I'm trying to get some clarity. I have a pending appeal based on the original order, but obviously the court's position as to whether or not the November 7 order supersedes and needs to be, language to that effect is what the issue is right now, Your Honor. And I apologize for this.
All right. Mr. Robertson.
Your Honor, I submitted the second order because I never got notice of the first order denying the reconsideration. I think the court stamp shows that it was not served on that date for whatever reason, but none of that really matters. It doesn't matter which order is relevant or supersedes the other, because the order for partition by sale signed by the court on July 25th is final, and it was final before the defendant's notice of appeal on October 31st. I have briefed this issue in my response to Mr. Hughey's motion, and it's very clear. A partition case consists of two orders that are both final and appealable. In the first order, which has been entered in this case, the court found the shared.
Isn't this gonna be a motion for the court, a matter for the Court of Appeals to take up? I don't think I can, that's not for this court to take up on that. I understand your position. I'm not saying
Right.
it's wrong, but I think that's just gonna be a matter that the Court of Appeals is going to have to rule upon.
Well, I'm sure that's right. I mean, the Court of Appeals is gonna rule on that, but
Yeah.
As far as which order overruling the reconsideration,
Do you have any objection to the original order signed by the court on October 21st?
I do, because I don't think that order is appealable. What is appealable is the order for partition by sale, not the order overruling the motion for reconsideration. The motion for reconsideration is an interlocutory order and it's not appealable. So that's my objection to that.
All right.
And that was the basis of my response, so that I filed with the new order denying the motion for reconsideration, which the court signed on November 7th.
Okay, all right. Just making sure I understand everybody. All right. Mr. Wilder, do you have a position in this matter?
No, Your Honor.
Okay. All right. All right. Well, again, I think I understand the legal reasoning behind all of this, but whether or not these orders are ultimately appealable or which order is appealable, I think the Court of Appeals will have to make that determination on this, on the matter. All right. So, I will, just to go ahead and get this moving on down the road, I will withdraw the November 7th order, and the October 21st order will stand on the motion. And because I think Mr. Hughey's already filed his motion to appeal on that, and then y'all can take it to the Court of Appeals and let them have what they may.
Thank you, Your Honor.
All right. All right. Anything further? All right, Mr. Hughey, if you'll just draft and submit a simple order to the court, withdrawing the November 7th order signed by the court.
Will do, Your Honor.
All right. Thank you, gentlemen. Y'all have a good day.
All right, Your Honor. You too.
Thank you.
Thank you, Judge.